I, on behalf of Beyond Law CLC, welcome you all to yet another webinar. As those who have stayed connected with us know the fact that the entire endeavor is that people within the profession and outside the profession, if they could be enriched with the knowledge from the speakers who have immense knowledge, and like we have today amongst us, Honorable Mr. Justice Mohit S. Shah, former Chief Justice of Bombay High Court, who has been a judge in Bombay, in Gujarat High Court as well as in Calcutta High Court. He was a gold medalist, and before we were going live to the platform, I was sharing with him. People actually were just latching upon to hear Justice Shah. I received large number of WhatsApp messages to the effect that the insights away from courtroom battles way forward would be a subject from hearing from Justice Shah would be a feature and which can be embedded in the memories in a way. And since we have been holding webinars, it's one of the rare occasions that large number of our earlier participants, not participants as such, earlier keynote speakers have also joined us. This again buttresses my fact to the effect that people actually want to hear to Justice Shah. And we always say there's a subtle difference between a webinar and a seminar. In a seminar, you can always have a captivated audience. That is a top boss like a vice chancellor coming in. He can ask the students to log in and they have to be in the seminar. Whereas in the webinar, a person who is actually interested to learn the nuances of any subject which he wants to will only do with his, once the speaker is of a magnetic personality, he can give the insights to different subjects. And during lockdown, to have a topic of away from courtroom battles, way forward, is a subject which, according to me, should be quite close to the people, because we all want to unlock the ways so that actually the delivery system could be better. Those who have joined slightly late, I can just say we have amongst us Justice Roshan Dalvi, who is a former judge of Bombay High Court. And those who have been connected with us on this platform, she had given insights of case management. So I would say that somewhat there can be an overlapping, because the entire endeavor of the away from courtroom battles is a step just like an alternate dispute redressal forum. But Justice Shah says that I will give it a different name. And as they say that some things should be kept to the speaker itself to address the name and the fashion it wants. Otherwise, the entire crux of the matter goes. And then we have amongst us Mr. P.K. Malhotra, who is a former law secretary, and Mr. Aseem Pandya, former president of Gujarat Bar Association and a senior advocate. He has also come on our platform as a speaker. He had also the privilege of Mr. P.K. Malhotra giving his insights. And apologies to those participants in case I missed the keynote speakers, because the way I received messages. I'm quite sacrosanct that large number of people who have come on this platform to address this. And I've been just informed, probably Justice S.D. Anand has also joined. I'm just checking it out. Yesterday, Justice S.D. Anand, judge from Punjab Haryana High Court, has also, he had given the insights on death penalties. So it only is buttressing the fact that Justice Shah, though gold medalist in his academic fields, speaks what he speaks is actually gold, and every ounce is a gold. Without taking much time, I will call upon Justice Shah to give his insights away from the courtroom battles. That will be a different facets, because one fact is there being on the virtual courts. Actually, we are at least away from the courtrooms as such, not physically in the real sense. Over to you, sir.
Thank you very much, Vikas, for this kind introduction. Let me begin by congratulating Team CLC, because I'm told that today is the 102nd webinar. So you are 102 not out, because you propose to continue this webinar series. So good luck to you. We must also begin our webinar with salutations to the frontline warriors, those who are fighting for us at great risk to their own lives. we have a lot to learn from medicine, but that I will tell you at the end of this webinar. Let me start with this. What is it that lawyers, because I believe the audience consists largely of lawyers and judges, retired judges, most of them. So what do the lawyers do? Now, whenever there is a debate amongst the professionals, what are the services being rendered by the professionals? Some people would say that, look, engineers build towers and construct engines and all that. What do the lawyers do? What cause it is that you can see a gentleman called Mr. John W. Davis, who was an American diplomat and a lawyer of more than 60 years standing. He spoke these beautiful words in the year 1946. So let me quote. True, we lawyers build no bridges, we raise no towers, we construct no engines, we paint no pictures. There is little of all that we do which the eye of man can see. But we smoothen out difficulties, we relieve stress. But we smoothen out difficulties, we relieve stress, we correct mistakes, we take up other men's burdens, and by our efforts, we make possible the peaceful life of men in a peaceful state. Rajat, we don't need this slide just now. So these are the beautiful words which Mr. John Davis spoke in the year 1946. Rajat, we don't need this slide just now. Now, the lawyers are doing the same thing in the year 2020, which they were doing in the year 1946 and even decades before that and centuries before that. So such is the noble profession of lawyers, and judges also come from lawyers. So we belong to the same profession, same noble profession. But friends, the harsh practical reality is such that if you ask a young lawyer how easy it is to find out a flat when he's looking for a flat on rent, what we call the leave and license basis, the answer. It's very difficult. Why? Why is it that people are reluctant to give out their flats on rent to lawyers? You might say that this is a little at a personal level. So let me go to the organizational level. There are many institutions and corporates who have framed rules for the disciplinary inquiries, domestic inquiries, whenever some employee or officer of that institution is facing some allegations and the department leads evidence against that person, delinquent. Delinquent is not allowed to engage the services of a lawyer. Why is it that most of these organizations are averse to permitting lawyers to be engaged for defending the delinquent? It's not only about lawyers. Let us also now consider the perception or the image which our institution has. What happens when somebody falls sick? Let us say he has an appendix problem. He has to go to the hospital to get himself operated upon. After a few months, he has to go to the hospital again because he has some other problem. That's a kidney problem. And a few months later, again, he has to go to the hospital because he has a cardiac problem. People will have sympathy for him. What happens to a person who goes to the court again and again? I'm not referring to the financial institution which gives loans to you for buying a car or buying a flat, etc. I'm referring to an ordinary person who goes to the court, files one case, files second case, files a third case. People will say he's a court bird. And that's not supposed to be a compliment, you know that. Well, actually, I realized the seriousness of this societal perception when I went to Marathwada. It's a part of Maharashtra. After becoming Chief Justice in the year 2010, when I went to Marathwada in summer of 2011, we went to a court complex and we found that the judges and lawyers were working in that building without any fans or lights. It was very difficult, almost impossible for them to function. And we tried to find out what was the reason. And we learned that because there was acute shortage of power. So there was power staggering between 12 noon and 2 o'clock in the afternoon. There was no light, no electricity. We said we had to find out some solution for this. So after going back to Bombay, we said, what is the problem? Why the electricity board is not giving us that express feeder line or the double express feeder line? And steps were taken. At the next follow-up meeting, one of our registrars said that the application is made and they will give us electricity, that express feeder line, within another week. But I said, what is the problem? So he said, sir, they ask us to give applications which they don't require from hospitals. Hospitals, they give the double feeder line or the express feeder line on their own. But from courts, they ask for an application. That time, it clicked that what is the societal perception about the role of an institution? Hospitals, is it the perception that hospitals render very useful services and therefore this facility is given to them without their asking on their own? The electricity board on its own gives this electricity? That is not the perception about the courts. Why such perception is not there? And that took my mind back to a case which we heard in Gujarat High Court a few months before I left Gujarat High Court in the year 2009. It was a matrimonial dispute. Nothing unusual about it. There are many matrimonial disputes. Here, there were 29 cases between the husband and the wife. The husband had filed a petition for divorce. The wife had filed applications for maintenance and many offshoots. So by the time the case reached before us in the High Court, there were already 29 cases. And we told them that you must go to the mediation center. We tried to persuade them because the mediation center was set up in the High Court just a couple of months back. And we found it very difficult to persuade them to go to mediation center because so much was the bitterness between the parties. And what was the level, what was the stage to which the bitterness had reached? You see, what had happened was that in one of the applications for maintenance, the wife filed an application for witness summons that the manager of the company where the husband was serving should be called as a witness. So he was summoned as a witness. He gave his evidence, produced documents. He was cross-examined by the wife's husband. And 1 month after this cross-examination was over, the manager terminated the services of the husband. He was working with a very good, Indian multinational corporation. It was a big shock for the husband. And he realized, or that was his assessment, that his services were terminated because the wife's lawyer had grilled him so much in the cross-examination that the manager felt upset, if not insulted. And he went back, and after 1 month, he terminated the husband's services. So the husband was so revengeful that he decided that he would like to see that the wife's services terminated. Wife was an Ayurvedic practitioner, and she was serving with a dispensary run by a charitable trust. So he started making applications to the charity commissioner, making allegations about financial irregularities by the charitable trust. His idea was that if the charitable trust dispensary is closed down, the wife will be rendered unemployed, just as the wife had rendered him unemployed, which was his assessment of the situation. It was at this stage that the matter had reached before us. And who do you think was the person suffering the utmost trauma because of this 29 cases? The couple had only one child, and that 12-year-old daughter was mentally challenged. So at a time when she required maximum love and affection and care from her parents, they were fighting out their battles in courtrooms. So friends, that is why the theme of my presentation today is that what can we do to see that we go away from courtrooms? Our dispute resolution should be by some other method. Friends, the reason why I want to emphasize this issue is that this is the bane of the adversarial system of litigation. When parties go to the court and they fight so bitterly that when they go to the court and see their lawyers coming out of the courtroom, during the lunch break and having tea together, they are upset that why is my lawyer having tea with the opponent's lawyer? They are supposed to fight. So how can they be friendly during the lunch break? So let us now analyze the dispute resolution process and why the courtroom battles are not giving us the satisfactory results. So we'll see that analysis of the dispute resolution process. Friends, what happens when there is a default? A person takes a loan and he's not able to repay the loan. So he will make a representation to the bank or the financial institution from which he has taken the loan. If the bank grants the loan, well and good, but there may be cases where there are differences between the parties. So what happens? The two parties negotiate. I would like you to see that slide on the analysis of dispute resolution process. Rajat. So when there are differences, the parties negotiate amongst themselves, between themselves. They do that without any third party. If the parties are able to resolve their differences on their own by the mutual negotiations, well and good. But very often, the negotiations don't succeed. So they have to have the dispute resolved with the help of a third party.
So just a minute.
The third party has to be a neutral party.
Rajat, kindly do that screen sharing.
So the dispute resolution has to be undertaken by a third neutral party. And this is what happens. See, we have the first stage where there is a default and the party makes a representation. If that does not succeed, and if there are differences between the parties, then they go for negotiations. If negotiations also fail, then the dispute has to be resolved within our legal system. And this resolution has to be undertaken by a third neutral party. Now, what happens is if the dispute is decided, the third neutral party, let us say the judge, gives a verdict, which is against the other party. The losing party has a lot of anger and bitterness. And then the next stage is reached. If the parties don't accept the verdict, they reach the next stage of conflict. There could be verbal abuses. There could be physical violence. So all that anger and bitterness is supposed to be a part of the conflict stage, not a part of the dispute resolution stage. What happens in the adversarial system of litigation is that the moment parties are before the court, that bitterness and anger starts right from the beginning of the dispute resolution process. And that is what the difficulty about the adversarial system of litigation. Now, friend, there are two basic dispute resolution methods. One is the right-based dispute resolution, which is called the adversarial system. So what we have in courts is a right-based dispute resolution. The third neutral party, the judge, looks at the law and gives the verdict. So also the tribunals. The arbitrators also are following the same method with some slight difference. The difference is that the arbitrators do not have to follow the Evidence Act or the Civil Procedure Code. And the intricacies of the legal system are more in the procedures than in the substantive laws. My professor in law college, Professor H.C. Dolakia, used to tell us in the very first year that the law professor knows the why of law, the judge knows the what of law, and the lawyer knows the how of law. So the lawyers master the intricacies of the Civil Procedure Code and the Evidence Act, and that is how the adversarial system is run with the help of these procedural laws. So in arbitration, the arbitrator is supposed to decide cases by basing his verdict or his award on the law and the usages of the trade, but not so much on the intricacies of the procedural laws. The other method of dispute resolution is the interest or need-based dispute resolution, where the third neutral party, who is a conciliator or a mediator, he tries to identify the causes of the dispute and he analyzes the factors. Once a gentleman, old gentleman, about 70-year-old gentleman, came to my house and said that first, because he said that he was teaching my daughter in a school. So he was coming to my place because he knew that I was my daughter's father as a judge. And I said, why have you come? So he said he has a case pending in the court, High Court. So I said, if you have a pending case, then you can't come before me. So he said, sir, I said, whatever you want to say, you can say that in the courtroom. You can instruct your lawyer. You can yourself also say whatever you want to say. So he said, no, sir, all that the lawyers are doing in the courtroom is to argue on the basis of the Supreme Court judgments or the High Court judgments and the provisions of the law. They are not discussing my problems. They are not discussing my difficulties. So, there is a perception amongst many litigants that what their cases are being decided on the basis of abstract legal principles without actually giving proper heed to their individual problems. So the interest or need-based dispute resolution concentrates on the facts of the case and the underlying causes and what is it that the parties really want and how their needs can be met. So this is a different method of dispute resolution, which is very different from the court processes. Now, what happens in the courts, I would like to notice right from the beginning, the next slide would tell you how the cause title in a court case is there and how the cause title in the other cases is there. See, when you file a case in the court, it is given some number, suit number or petition number. Then the parties' names are given. They are described as plaintiff or petitioner versus defendant or opponent. So versus means they are treated as opponents from the word go. As against that, in arbitration and other dispute resolution methods, the parties are described by their names, but they are not shown as opponents. They are shown as ABC and XYZ, not ABC versus XYZ. So this is the subtle difference, that the adversarial system of litigation puts parties against each other right from the first application or the first petition being filed by the plaintiff or the petitioner, where the other side is being described as an opponent. And this is the bitterness starts so early in this process that when, let us say, in a matrimonial dispute, the lawyer will give notice on behalf of one spouse to the other spouse. In the notice itself, there will be such serious allegations. The allegations may be exaggerated. The allegations may be distorted. But because it is supposed to be a fight, the lawyer starts with his notice with such serious allegations. The other side will give a reply. Then there will be petition in the court with same allegations, such sometimes so scandalous allegations that their allegations are made against the spouse, against the family members. And then at a later stage, it becomes almost impossible for the judge or the mediators to bring the parties together because the allegations are made at such a level that it is impossible for the parties then to take a U-turn. So the reason why it is necessary to keep this perception in mind right from the beginning is this, that the adversarial system of litigation introduces that bitterness which needs to be nipped in the bud right from the beginning. That is why there is a suggestion that the rules of the family court and many other litigation branches should be amended to see that in the first notice or in the petition itself, there should not be serious allegations. The petition should only say that there are serious differences between the parties. Therefore, they have come to the court, and then the court can send them for appropriate dispute resolution process. Now, there are several methods for dispute resolution. We saw that there could be arbitration, there could be mediation, could be conciliation. So which is the appropriate dispute resolution method? Now, friends, what happens is that till now, all these other dispute resolution methods like arbitration, conciliation, lok adalats were always being described as alternative dispute resolution. And therefore, the litigants who were told that they have to go for some alternative dispute resolution process did not like the idea. It was like saying that a person who wants to buy a car, he is told that, oh, you can't afford to buy a new car, so you buy a second-hand car. So that is what the witness, that is what the parties are sometimes told, that the courts are very busy with other cases. Courts may not have the time. Therefore, you better go for some other method. Now, that is not the correct method of guiding a party to proper dispute resolution, because the dispute resolution process which is appropriate will depend on the facts of the case, will depend on the nature of the litigation. Now, for instance, in commercial disputes, arbitration is very often considered as a very appropriate dispute resolution process. Arbitration is something which is as old as the court system itself, because we all know that we have been having panchayats in the villages, elders in the families or panchayats in the villages, they were resolving the disputes among the parties. So also among the business people, the trade associations each trade association would have a Mahajan, like a textile traders association would have Maskati Mahajan. In Ahmedabad, they were very popular. In Mumbai also, they were very popular, and people did not have to go to court to have their disputes resolved. At that time, arbitration was done little differently than the method of arbitration being followed at present. Aristotle said this as far back as 300 years before Christ. It is equitable to be patient under wrong, to be willing that a difference shall be settled by discussion rather than by force, to agree to arbitration rather than to go to court. For the umpire in an arbitration looks to equity, whereas the juryman sees only the law. Indeed, arbitration was devised to the end that equity might have full sway. But now arbitrators are also supposed to follow the law. But not only the law, but also usages of the trade. And that is a very important leeway for the arbitrator to see the practical realities of the dispute between the traders, because trade usages can play a very important role, which can help the parties to explain their contract. You know, contract is a written instrument, and very often the arguments are about the language of the contract. But while explaining the language of the contract, the parties, the traders can refer to the usages of the trade, that this was the context in which the contract was framed. Secondly, as I said earlier, the arbitral tribunal does not have to follow the strict procedural laws like Evidence Act and the Civil Procedure Code. They have to follow the underlying principles of natural justice. And therefore, there is a lot of procedural simplicity and flexibility. You see, the advantages of arbitration are that there is party autonomy for choosing the arbitrator. In court, your case has to be heard and decided by the judge to whom the case is assigned by the principal district judge or by the Chief Justice of the High Court. If you try to see that your case comes up before a particular judge, then it will be said that you are trying to do forum shopping or the bench hunting, and which is frowned upon. But in arbitration, it is in fact the choice of the parties to go for the arbitrator of their choice. So if there are two parties having a dispute, they can both jointly decide that they will go to person X, who could be a retired judge, who could be even a lawyer, or who could be a non-legal person. It is not necessary that he has to be a law person. If parties want three arbitrators in many commercial disputes of high stakes, one party selects his arbitrator, the other party selects his arbitrator, and then two of them decide upon the presiding arbitrator. So all along, the parties have their autonomy in choosing their arbitrators. In many technical contract matters, experts like engineers are selected as arbitrators. The second advantage is the procedural simplicity and flexibility. The flexibility is to such an extent that arbitration meetings can be held on Saturdays, Sundays, even on holidays, public holiday, with the consent of the parties, the meeting can be held. The meeting can be held at 10 o'clock in the morning. It can be held 6 o'clock in the evening. I had a case as the sole arbitrator where we had a witness from Bangkok, and he was landing in Mumbai by early morning flight, and he had booked a late night flight the same day. So our meeting started at 10:30 and continued till 7 o'clock, except just one lunch break and a coffee break. So these are the advantages of having a dispute resolution method, which has so much flexibility also, about convenience of time and place for meetings. Then the most important thing is the privacy and the confidentiality. In a courtroom, you have a dispute between two brothers, family members, or a dispute between spouses, or a dispute between business partners. Now, courts are public places, so anybody from the public can have access to court. He can sit in the courtroom. He cannot be told to go out of the courtroom unless the camera is to be held by trial, in domestic violence cases or child abuse cases. The judge may say that, well, the others will go out. But otherwise, in all ordinary court cases, the court trials are open to the general public. So now these days, people want their privacy and confidentiality. So arbitration gives this advantage, which courtroom battles cannot give you. Another advantage is the informality. In courtrooms, everybody is attired in the formal court dress, the coat and the gown and the bands and everything. Now in arbitration, of course, you are not supposed to be in casual clothes, but you are not also supposed to wear those gowns and bands. So with the result that the atmosphere is a little more informal. It is informal to such an extent that when the lawyers are arguing their cases, tea and coffee can be served. So a party can sip from his cup of tea when his lawyer is arguing before the arbitrator. And when you have a cup of coffee as well as a plate of biscuits before you, it's difficult to clench your teeth. So therefore, there is less anger in arbitration, less aggression in arbitration than what you normally see in the courtroom battles. Then the advantage is also speedier resolution, because courts are burdened with a large number of cases each day. Every day the court has 50 cases, 100 cases. The arbitrator would be having only 1 or 2 cases, so more time can be devoted. So these are the advantages of arbitration, and therefore arbitration has become a popular dispute resolution method amongst the businessmen. Now, there are lok adalats. You must have all heard about lok adalats, where periodical lok adalats are being held for settlement of disputes, and they are very popular in motor vehicle accident cases. They are also popular in matrimonial disputes in the rural or semi-rural areas. Now, these are periodical lok adalats, and they settle a large number of cases. Last year, in the calendar year 2019, in Gujarat, 375,000 cases were settled at periodical lok adalats. And in Maharashtra, more than 5 lakh cases were settled in periodical lok adalats. Then there are permanent lok adalats. Now, permanent lok adalats are lok adalats for settlement of disputes or even adjudication of disputes up to rupees 10 lakhs against public utilities. You have a case against the municipal corporation for the bill that they have served, or the electricity company. Now, if your disputes are up to rupees 10 lakhs, you can go to the permanent lok adalat. This unique feature of the permanent lok adalats, about which many of the people are not aware, is that at permanent lok adalats, the cases are placed for settlements in the first place. But in case the cases are not settled, then the lok adalats have the power to decide the cases on merits, like adjudication of disputes, what we call, and they can give verdicts which are binding. Now, the lok adalats, permanent lok adalats, when they decide cases, they the permanent Lok Adalat shall, while conducting conciliation proceedings or deciding a dispute on merit, this is what section 22D of the of the Legal Service Authority Act says, be guided by the principles of natural justice, objectivity, fair play, equity, and other principles of justice, and shall not be bound by the Code of Civil Procedure and the Indian Evidence Act. So this is also a good forum for settlement as well as adjudication of disputes against public utilities. But if there are other categories of cases, they can be settled at Lok Adalats by negotiations, where the third neutral party, the conciliator, the retired judges or the lawyers, help the parties to arrive at settlements. Now, friends, till now, these methods of dispute resolution were being followed. What was common amongst these features of traditional ADR was this, that the third neutral parties, what we call conciliators or even arbitrators, they would be asserting their moral authority. But what happens these days is that the awe of authority is declining. Let me just give you a simple illustration. As children, when we were going to schools, our parents would tell the teachers that you can spank my child if he or she does not study properly. It would be generally he, because girls always were more sincere, and even now more sincere, which we see in schools as well as colleges. So the parents would tell the teacher that if my son is not studying properly, you can spank him. And the teacher had that liberty, and he used to exercise that authority. But if that teacher does that now, what will happen? Immediately the parents would go to the principal and say that, why did the teacher did this? The awe of authority is declining. The other feature of traditional ADR is the call for sacrifices. So if there is a dispute between family members, there are two brothers, the elder in the family or even a judge would tell the elder brother that you must make some sacrifice. After all, the defendant is your younger brother. Same thing, the younger brother would be told that after all, he is your elder brother, you must make sacrifices. But you know what happens these days? Nobody likes to make sacrifices. Everybody has a preference for self-interest. Here also, let me give you one very simple illustration. A boy did his graduation in India, did his engineering, and then went to USA for doing his post-graduation. There he started reading. The parents in India had, taken loans from their provident fund and other sources to spend for his traveling to USA and for paying his fees, tuition fees and other expenses. After a few months, this boy said that, he has started reading some Swami's scriptures and he is getting interested in them and he would not like to continue his studies. So his friends told him, how can you do this? Your parents have made such sacrifices and you are giving up all that. You must think of your parents. So he said, no, I have done whatever my parents did for the last 25 years. Now I want to do what I feel like doing. It was at that stage that the boy went to, happened to meet my elder brother in USA, who is a medical oncologist. So he has to do a lot of counseling to the cancer patients and more to their relatives. So my brother told him that, look, what you are saying is right. If you want to follow this Swami and his teachings, there's nothing wrong with it. But right now you are only 25. Even for following your Swami's teachings, you will have to do something for your livelihood. No? So he said, I am not interested in money. I don't want big cars. So my brother, Dr. Suresh Bhai, he's told him that, if you take up a job, an ordinary menial job, he said, I can become a waiter with McDonald's. So he said, but then you'll have to work for 12 hours and you won't earn enough for you to save money that you can use that money for following your teachers, your Swami's teachings. So if you have to work for 12 hours, you won't be left with any time or any energy for following your Swami's teachings. So then he realized it, that this makes sense. So he said, then I should continue my studies. So he said he'll continue his studies post-graduation studies for a year and a half more, and then he'll complete the studies. By that time he could finish his studies, then he changes his mind. So friends, the preference for self-interest is so important that if a conciliator simply says that, well, you have to make a sacrifices for your elder brother or younger brother, nobody is going to follow that. So we'll have to find out some new formula, some new principle, some new philosophy for making this dispute resolution method succeed. The third feature of the traditional ADR, the traditional conciliation, was that they will say you have to make compromises. So if the husband and wife have disputes, they will say, no, you must make compromise. The wife must go back to the matrimonial home. And this used to happen in khap panchayats. Khap panchayats. The pressure would be on the wife to go back to the husband's house, even if the husband is beating him up. So the traditional ADR was not successful in cases which required more sensitive treatment in disputes which were not ordinary simple disputes which could be simply resolved by this 50-50 compromise formula. The fourth was, as I said earlier, the confidentiality and the privacy which parties want. We know that these days even the teenagers, when they are talking on mobile, and suppose we are family or others sitting together and a teenager gets a call on his or her mobile, he or she would immediately go to the next room. Now, it is not that they are doing something wrong or illegal, but even for ordinary talks, they would like to have that confidentiality and privacy. Now, if you don't have this confidentiality or privacy in the dispute resolution process, what will happen? The parties will not feel comfortable. Therefore, now we have to look for a dispute resolution method which has the advantages and which keep away the disadvantages which we just now discussed. So we have a dispute resolution system called mediation, where you have the choice of mediator. Then you have the appropriate environment where you have the privacy and confidentiality. You have the informality, the flexibility, and the continuity. So we know that, when parties have disputes cannot be resolved at the first meeting. There will have to be several meetings and they will continue to meet. There will be informality, and this is very important about mediation. During mediation training, we always tell the trainees that as far as possible, lawyers and judges who are doing mediation, they should avoid wearing black coats, because black coats are identified with that adversarial system of litigation, that opponents, the bitterness, the revenge environment. So in mediation, we have informality, we have flexibility, we have continuity. And the important thing is it caters to the underlying interests of parties. I will also like to have the next slide about involving parties in the process of finding creative and innovative solutions. What happens in a courtroom when a case is being argued by a lawyer, the party wants to say something and he will be immediately told that, no, you have engaged a lawyer, so only a lawyer can speak. But in mediation, the parties are also encouraged to speak. In fact, at the first meeting, after the lawyers give the brief introduction, it is the parties who are supposed to give vent to their feelings. So even if they get a little agitated, it's fine, because the very fact that they are allowed to give vent to their feelings, the feelings which have been bottled up for so many years, they feel good about it. And that is the very first step for dispute resolution, to give vent to their feelings. Now what the parties have a problem, the problem is because of some underlying interests of the parties. Now let me give you an illustration. A person has booked a flat with a builder and there is delay in giving possession of the flat, and the flat is given after a couple of years. What happens? The purchaser of the flat, he will say that, look, there was delay, so you must pay me the penalty or the interest. Now the interest is comparatively a small component. the builder will say that, well, I took all the steps, necessary steps, but the municipal corporation gave me building permission very late. There were many other reasons where the regulatory authorities took a lot of time. So I am not liable to pay any penalty. In a case like this, the mediator is able to bring the parties together in such a manner that the mediator can arrange for the private sessions also. This is very important about mediation, which you will not find either in courtroom battles or in arbitration also. In mediation, in the beginning, the mediator can explain the process to the parties and say that, look, we will have combined sessions, common sessions, as well as we will have private sessions. So in the common sessions, all the parties are together with the mediator. In the separate sessions, which process is also followed with the consent of the other side, the mediator will call one party to discuss with him, and the other party will be waiting outside. Thereafter, the first party will go out, and then the second party will come in and discuss with the mediator. So during these private sessions, the parties will, open their heart out and tell the mediator what is it that they really want, what are the problems. This is very necessary, not only in matrimonial disputes, but even in commercial disputes, or even in the dispute which we have been discussing about, the dispute between the builder and the flat purchaser. The builder may tell the mediator in the private session that, look, I have no problem giving a few lakhs of rupees. The flat was 50 lakhs, worth 50 lakhs of rupees. The party has paid me 50 lakhs of rupees. I don't mind paying 4 or 5 lakhs of rupees to the flat purchaser, but then it will amount to an admission that I committed default, that I was responsible for the delay. Therefore, I don't want to pay 5 lakhs of rupees. But if there is some other method through which I can pay this 5 lakhs of rupees, I don't mind. So the mediator will discuss this with the flat purchaser, who will say that, look, I want to use this money for using, false ceiling, making false ceiling in my drawing room, for having modular kitchen in the kitchen. Then in the common session, the mediator can discuss this with the builder and the flat purchaser. So the builder will say that, okay, I will give the false ceiling, and the modular kitchen to the purchaser at my own expense. So the flat purchaser gets what he wants. The builder gets what he wants. What he wanted was that he didn't want this stigma of a penalty. He was ready to give the money, but not with the stigma of the penalty. So both the parties are happy. The mediator could see that the mediation process catered to the underlying interests of the parties. The parties were involved in the process of finding out creative solutions, and they looked forward to a better future. What happens in courtroom battles or even in arbitration is that the third neutral party and the parties keep looking to the past. Who was responsible for the fault? Who was responsible for the delay? Whereas in mediation, the parties and the mediator helps the parties to look forward to a better future. So not to concentrate on the past or who was at fault, but to look towards the future for finding out a solution. So these are the advantages of mediation. But friends, to be a good mediator, a person needs both sensitivity and training. A mediator is a person who can offer his shoulder to people to cry on, but then he is not supposed to cry along with the parties. He is sensitive, therefore he is able to understand their problems and to help them to clear the clogged channels of communication, for which he needs proper training. And training is very important. We trained about 1,000 judges, more than 1,000 judges in Maharashtra during my tenure. That was between 2010 and 2015. And with the result that it gave very good results. I'll just show you the figures a little later. No, just before the figures, we'll complete this. So what the unique feature about mediation is that, like arbitration, like Lok Adalat, it is also a part of the existing legal system. That is why the Commercial Courts Act now says that mediation should be made compulsory. Of course, for the present, it is stated that feature is kept on hold, but sooner or later that is bound to come. The mediation center as a part of the dispute resolution process is getting more and more popular. Therefore, now we have court annexed mediation centers. In Delhi, we have court annexed mediation centers. In Bangalore, in Bombay, in the Bombay High Court, we have court annexed mediation centers. In Gujarat High Court, we have court annexed mediation centers. So it gives the parties the feeling that when they are told to go for mediation, they are not going for an alternative dispute resolution system. They are going to a forum which is very much a part of the dispute resolution process. So, friends, next I'll show you those figures of cases which we settled in by mediation in Maharashtra. Rajat, slide number 10. See, we gave training to the mediators in the year 2011 and opened the mediation centers. The percentage figure is getting concealed. So if you can shift the slide slightly. So in the year 2012, more than 21,000 cases were settled by mediation, and that was 39%. In 2013, more than 35,000 cases were settled. The success percentage was 54. In 2014, 33,000, success ratio was 57%. Next year, 28,000, 56% success ratio. And in the year 2016, success ratio was 53%. So that is why mediation has become so popular in USA that 90% of the cases are being settled by mediation, 90% of the civil cases. And therefore, I would like you to carefully listen to these words of Chief Justice Warren Burger, the former Chief Justice of US Supreme Court. Quote, "The entire legal profession, lawyers, judges, law school teachers, has become so mesmerized with the stimulation of the courtroom contest that we tend to forget that we should be healers of conflict." We don't need any slide just now. We tend to forget that we should be healers of conflict. The notion that ordinary people want black-robed judges, well-dressed lawyers, and fine-paneled courtrooms as a setting to resolve their disputes is not correct. People with legal problem, like people with pain, want relief, and they want it as quickly and inexpensively as possible. The obligation of the legal profession is to be healers of conflicts. And same thing was said by the father of our nation, Mahatma Gandhi. He had gone to South Africa and he had very good large legal practice there, but he was able to help the parties to settle most of the cases. And he said this, both were happy with the result, the parties who settled the cases, and both rose in public estimation. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing out private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. Now, many of you will say that, sir, it's all right for Gandhiji to say that, but for us, we also have to earn our livelihood. So, yes, let me be frank. There are two answers to this. The first answer is that during Corona times, Gandhian philosophy is the best philosophy. Our needs are minimum. But that was in the lighter vein. The real answer is, as I said just now, 90% of the civil cases in USA, we had visited California and seen for ourselves that there were only about 20 people in a court complex, very few lawyers and very few litigants. But when we went to the mediation center, there were hundreds of people. There were 42 trained mediators specialized in different fields who were helping the parties to settle the cases by mediation. So friends, mediation is also a good dispute resolution method for earnings of lawyers also. We all know that lawyers in USA are not known to be poor. Therefore, in India also, we can follow these methods. So friends, now I want to tell you that the Parliament has already visualized this scenario while enacting Section 89 and Order 10, Rules 1A and 1C of the Civil Procedure Code, the courts have now become a multi-door courthouse. So it's not just somebody goes to court and he has to litigate. He can go for arbitration, he can go to Lok Adalats, he can go for conciliation, he can go for mediation. So now it is a multi-door courthouse. Multi-door courthouse means when you go to a court complex, one door opens into a room which leads you to which leads you to arbitration. Second, to Lok Adalat. Third, to mediation. Fourth, to conciliation. Fifth, to judge settlement. The judge helps you to settle the cases. And then trial. Or if you are not satisfied with the verdict in the trial, then you go in appeal. So let me now quote the words of Professor Frank Sender, who is very famous for these words. Please reimagine. Slide will show you the quotation from Professor Frank Sender. Please reimagine the civil courts as a collection of dispute resolution procedures tailored to fit the variety of disputes that parties bring to the justice system. You see, therefore, court is not a place where you have to go to the courtroom and fight it out as a battle, because the courts, civil courts, have now become a multi-door courthouse where there is a collection of dispute resolution procedures and they are tailored to fit the variety of disputes that parties bring to the justice system. These are the words of Professor Frank Sender, which he spoke in the year 1976. He was a professor at the Harvard Law School, and he is very well known for these expressions, multi-door courthouse and collection of dispute resolution procedures. Now, friends, the beauty of this system, multi-door courthouse, is that they are not watertight compartments. Means when you go to arbitration, it is not necessary that you have to fight till the end. Arbitration Act itself now specifically encourages this spirit of settlement, and it says in section 30, it is not incompatible with an arbitration agreement for an arbitration tribunal to encourage settlement of disputes, and with the agreement of the parties, the tribunal may use mediation, conciliation, or other procedures at any time during the arbitral proceedings to encourage settlement. Then the Arbitration Act also gives power to the arbitrator to fix reasonable rate of interest in absence of contract between the parties. Then the important amendment made in the year 2015 is the regime for costs. So where a person, one of the parties says that I'm ready to settle on these terms, and the other party does not accept it. So even if the second party succeeds finally, the tribunal will say that, look, the first party had made this reasonable offer, but you did not accept it, so I will not award you costs. You might have spent lakhs of rupees for your lawyer's fees, but it was open to you to accept this reasonable offer made by the other party, and therefore I will not award you the lawyer's fees. Now you will say that, sir, it is true that this appropriate dispute resolution methods should be followed, but it is not possible to send hundreds or thousands or lakhs of cases from civil court to mediation centers. We accept that. It is not possible to transfer all cases to mediation centers or to settle all cases at mediation centers or to have them decided by arbitral tribunals or settled at Lok Adalats. So what can we do? The next best thing that we can do, and this is what I want to impress upon all the participants at the webinar today, is that even if a case is not settled by mediation, even if you do not go to mediation center, you can definitely bring the spirit of mediation into courtroom by doing away with that bitterness, by doing away with that giving up that spirit of revenge which the parties have when they are before courts. And therefore, please don't encourage the parties that when a case starts, a battle has started. Don't use the words versus or opponents. Use the word A, B, C, and X, Y, Z. Plaintiff and defendant. Don't use the word petitioner and opponent. Second is don't run down your opponent or the witness of the other party. You know what happens in a trial, just as I referred to that matrimonial dispute where the husband lost his job. The cross-examination is one of the methods of bringing out the truth, but you do not have to go to the level at which sometimes cross-examination is being conducted. I know all lawyers don't do that way. In fact, not the majority of lawyers are not like that, but some lawyers do that. And then they cannot be stopped from doing it because the judge will say they are acting within the four corners of law. Therefore, we must bring this spirit of mediation into courtroom and impress upon all concerned. The judge can impress upon the lawyers and the parties, and the lawyers can impress upon their litigants. The senior lawyers can impress upon their junior lawyers that these are not battles that we start the fight with bitterness. Bitterness can come only if the case is finally decided and it is not acceptable to a party. But till the verdict is given by the court, please don't allow bitterness to sip in to the dispute resolution process. Now, the law itself contemplates all this, that this spirit, which are the stages at which this spirit can come in, can creep in. Just see CPC Order 10 Rule 2, which is the rule for the first hearing. It is there since ages, but unfortunately this rule is not being applied. Oral examination of party or companion of party at the first hearing of the suit. At the first hearing of the suit, the court shall. Earlier it was may, but the Law Commission said that make it mandatory. And therefore the Parliament has made it mandatory that at first hearing of the suit, the court shall, with a view to elucidating matters and controversy in the suit, examine orally such of the parties to the suit appearing in person or present in court as it deems fit. So this is important. The judge is supposed to put questions to the parties at the very first hearing. Now, obviously, the judge is not supposed to ask the party which Supreme Court judgments are you going to rely upon or which provisions of law are you invoking. The judge is going to ask the basic facts to the parties, those underlying interests of the parties. So if the party has not repaid the loan, you took the loan, no? So the party will say that, yes, I did take the loan, but I have this problem. So I was doing bad in business, so I want some more time. So you see the controversy will be immediately be narrowed down and the parties will find it easier to settle the cases. Because if a party on its own says that I want to settle a case, some people might say that he'll be considered as a weak party. So a party is not always ready to offer settlement. So if the court takes the initiative or if the third neutral party takes the initiative, then it will be easier for the parties to settle. So similarly, at the stage of interim injunction or at the stage of interim stay, the court has the discretion. Now, let me just refer to this, what the court can do at the final judgment stage. The court can mold reliefs. The best illustration of using mediation for molding of reliefs is the recent case in the Ayodhya dispute case. The dispute was about 2.55 acres of land, 2.5 acres of land. What happens in an adversarial system? The successful party gets everything, the losing party gets nothing. In this case, the court said that the successful party, one party, was entitled to take 2.55 acres of land, which was the disputed land. But at the same time, the other party was required to be given 5 acres of land in the vicinity, nearby Ayodhya. But the lawyers will say that this judgment was under Article 142 of the Constitution. Am I audible? Hello? Okay. Am I audible? Okay. I'm not able to hear. Okay. The Article 142 of the Constitution says that the Supreme Court has the power to do complete justice. But what about other courts? I became a judge in the year 1995. And very soon after I became a judge, I came across this judgment of the Supreme Court in B.C. Chaturvedi versus Union of India, where Justice Hansaria gave these beautiful lines. And he gave this as an authoritative pronouncement on interpretation of the Constitution and the laws. He said, of course, Article 142 specifically gives this power to the Supreme Court, but it would be wrong to think that the other courts are not to do complete justice between the parties. So the Supreme Court itself has laid down that the other courts also have to do complete justice, and therefore they can do complete justice by molding of reliefs properly. And therefore the high courts as well as the trial courts can rely on this judgment for exercising their powers for the purpose of molding reliefs. Now, friends, I told you at the beginning that we have a lot to learn from medicine, from the doctors. What happens when a person falls sick? People generally go to the family practitioners, the GP, general practitioners. Out of 100 people, 80 people get cured. The remaining 20 people, they go to the specialist, the MD consultant, who will examine the patient and give some treatment, some medicines. 15 people get cured. So 80 plus 15, 95 people get cured. 5 people still are sick. So they go to the hospital and get admitted to the hospital as indoor patients. They get some treatment. Out of 5, 4 get cured. So only one person who is still sick, and the doctors will advise him that you need to undergo surgery. So out of 100 patients, only one undergoes surgery. You know, surgery is as stressful and expensive as trial in a courtroom case is. Now, what happens when a party has a problem, legal problem, and he goes to a lawyer? He'll be advised to file a case, to go to court, file a case and fight it out for 10 years before the trial court, another 10 years before the appellate court, and then further going to the Supreme Court. So can we not learn this lesson from our friends in the medical fraternity, that we can advise our clients to avail of the appropriate dispute resolution procedures first, and only if those procedures fail, then only the parties can be advised to go for surgery or what we call trial in our system. So friends, if we keep this perspective in our mind, I'm sure very soon the lawyers and judges will be able to help the parties to resolve their disputes more satisfactorily, rather than asking them to go for courtroom battles. And once this results will be seen, people will be surprised. At first, this is what Francis Burnett said. At first, people refuse to believe that a strange new thing can be done. Then they begin to hope it can be done. Then they see it can be done. Then it is done. And all the world wonders why it was not done centuries ago. So friends, once we start implementing this philosophy, then the results will be obvious, and we will all wonder, why did we not try it out earlier? Thank you. Thank you so much, Vikas and your team, for giving me this opportunity. I would also like to thank my team of Sahil Shah, Rajat Gupta, Parth Shah, and Janita Lale, who have helped me for this preparing for this webinar. Thank you so much.
So before we take the questions, I will just inform. I just missed out. Justice Vineet Kothari, judge from the Madras High Court, has also joined. He's also a judge from, earlier he was from Rajasthan.
Welcome.
Just insights from Justice Vineet Kothari. He's an erudite speaker just like you. He can give insights on different aspects.
Most welcome, Brother Justice Kothari.
I am fan of Justice Mohit Bhai Shah.
Thank you.
How are you, sir? With
Fine,
his
fine.
rich and long experience.
Nice to meet you at this webinar.
Judge of Fact, Chief Justice of Bombay High Court. And though we have met very less number of times, but I have been reading his Lordship's judgments. And of course, I treat him as elder and friend and guide also. So very happy to listen to you for the last 10-15 minutes, sir. I joined a little late, I'm sorry. But you were directly, I think, encouraging, and all lawyers also to develop this alternative system, TPC, all details provision section 10, I was listening to. So it's very good that we have to create, I think, in my humble opinion, a mechanism as sound as the court system has used to be. But now with the delays in the judicial dispensation we suffer, developing the mediation and the quicker processes in the courts also is very necessary. And with the increased infrastructure size and this mediation and other things, we can definitely achieve the target of quick access to justice to all. And I really thank Vikas for allowing me to join.
And also, the pleasure is
for
all
your
ours.
inputs.
Yeah.
Yes, please.
So I am seeing some.
Hari had been with us.
Yeah,
Yes.
I had one webinar of Vikas organized by him on money laundering, PML.
Okay.
So nice to see you, sir. Please.
Thank you. Thank you so much for your kind words.
Pleasure.
Yes, Vikas, any questions?
Yes, sir. This is by Advocate Ayas. Before we take the questions, the participants can post the questions since the speaker has consented to answer in his own way. And we have Justice Roshan Dalvi. She also had delivered a talk. We know that she's also for ADR section.
She is an also expert, not only an expert speaker, but expert trainer for mediation. At our mediation centers in all over India, she has been giving training on mediation and case management. Yes. Yes.
This is by, just hold on.
Please continue.
This is by Advocate Ayas. When a party mediated and settled an agreement. We are unmuting Ayas somehow. Ayas, Faizaboy, we are unmuting you. You can ask the question directly.
Good evening, sir.
Good evening.
Sir, there is a settlement agreement which has been signed before lockdown period, 9 months. And the 5 parties to the agreement now have a dispute over some minor issues. So 2 parties don't want to execute that. It is a final as per 73, section 73 or Arbitration Conciliation Act.
Yes.
There is a mediation offer by those 2 parties to fresh mediation. My question is, sir, will the fresh mediation compromise or void the old settlement?
No, if the old settlement was signed by the parties in writing, then of course it can be enforced as an agreement. It can be enforced.
And there will be no void, or it will not be vitiating the settlement if a fresh issue of mediation arose and conducted.
Fresh mediation can be conducted, but the old settlement, if it is signed by all the parties, will be binding on the parties as an agreement.
Much obliged. Much obliged. Thank you, sir. Thank you.
May I ask one question to Justice Shah, please?
Yes, yes.
So, good evening, sir. It was indeed a wonderful session. I really enjoyed. In fact, I must inform Mr. Vikas that when Justice Shah was in Gujarat, he was the pioneer in establishing mediation center. And I was one of the first batch who has undertaken the training. So it was really indeed a very good lecture today, webinar. Now, one thing which is constantly worrying me is that when the matters reach High Court, there are almost 2 decisions in favor of one party. So at High Court level, the mediation, my personal experience, because I have also mediated a number of times. And now after going, your lordships going, the mediation center is not that happily working there. And the success ratio is very low. So why should we not introduce this mediation, mandatory mediation at pre-litigation stage? Because there are a number of cases where this can work very well. Or I can give one illustration, that is consumer cases. Consumer cases, consumers are interested in redressal of their grievance at the earliest. So there it should be made mandatory to go through a mediation process at the initial stage, and only if it fails, then only it has to be referred to the consumer court. And second is one area where number of cases are pending, and which is the large segment of backlog, that is 138 cases. So 138 cases are also quasi-criminal because earlier, before
No,
1989,
but
it was not
one,
offense.
138 cases are quasi-criminal, but they are, eminently fit for mediation. There is
Yes,
no
yes. So in those cases, why should it not be made mandatory to go through this mediation before it is placed before the competent court? That would avoid the great backlog.
But you know that in Commercial Courts Act, this provision was there. I mean, is still there, making mediation mandatory, but it is not for the present being implemented. What happens is that just like it used to happen under the Industrial Disputes Act, if you make it mandatory, then it is not necessary that it will succeed as a movement. My view is that let it start and continue as a movement, and then once it picks up, then people will on their own say that yes, mediation is a good thing, it should be made compulsory. But making it compulsory at this stage, when people are not yet ready, there may not be enough trained mediators, it will create roadblocks. Therefore, my personal view is that instead of making it mandatory, it should be popularized amongst the litigants and parties.
The only difference between the other countries and India is that in India, before court, a case reaches to a court, there are large number of persons who intervene and they try to bring settlement. And therefore, when it reaches the court, it is as a last resort, usually the case reached. In America and other countries, there is no such social, mediation in this sense, which is being done in India. So their mediation works very well. But so far as
I understand. But if you see now, the people who are in urban areas, they are almost in majority, I would say. As compared to rural areas, people in urban areas are in majority. Every year, about 80 to 90 lakh, almost 1 crore people keep migrating every year from rural areas to urban areas. And in urban areas, we have these problems of isolation, anonymity, loss of identity. So basically, we are now almost following the same social milieu, which is now there, which was earlier there in the Western countries and now also there. Therefore, mediation is now likely to succeed more. It is required more in the urban setting than in the rural setting.
Thank you very much.
I also see Ms. Mrinalini Deshmukh, the senior advocate practicing in the family courts. So we would like to have some inputs from her.
We are just unmuting her.
Yes.
So we are unmuting Mrinalini. Meanwhile, sir, we have Justice Maushmi Bhattacharya. She's a sitting judge from Calcutta High Court. She has also joined.
Yes, please. Welcome.
Yes, thank you very much, Justice Shah, for a very different and enlightening
nice meeting
session.
You at this webinar. Yes.
Yes, in fact, I was at the bar when you when you graced our High Court as its chief, and then of course I, like many others, were very sorry to lose you.
Thank you for your kind word. I also miss Calcutta High Court. I was there for 6 months. Yes.
Yes. So I just, it is interesting that you brought up the Commercial Courts aspect, because Section 12A of the Commercial Courts Act has now made pre-institution mediation mandatory.
Compulsory, yes.
And yes, that's right. And of course, provided parties have come to the conclusion that no interim order, or rather the plaintiff has come to the conclusion that no interim order is required. And it is a good provision because it also gives a mandatory outer limit, which is of 3 months for the parties to mediate and see if the dispute can be resolved. And in fact, the other day, a plaint was presented in my court, and apart from the order to rule to leave, which was sought, there was also a prayer for leave under Section 12A of the Commercial Courts Act.
So what do you suggest?
So I think that it's a very welcome step forward.
Yes.
And your thought right now about this migration from the rural to the urban areas also brings forth, a sociological aspect of the problem. And, the factors of isolation and, being by oneself, as opposed to the general notion of being in a group actually is very conducive to mediation.
Yes.
And I think the present pandemic situation has really highlighted the need for alternative dispute mechanism, which was always there. But now that with the courts functioning, at the virtual level, and people may, having maybe facing difficulty in accessing the courts, who had only depended
Actually,
on
there can be online mediation also, online arbitration
That's
also.
right, absolutely.
I have been conducting one online mediation also.
Yes, and personally, Justice Shah, I am of the view that online mediation, online arbitrations, the online virtual platform is actually much better suited to these kinds of ADRs rather than the court processes itself, for a variety of reasons.
Correct.
So I don't want to really, this is not about, my comment, but really to thank you for a very enjoyable session on a Tuesday afternoon, and a very good evening also to Justice Dalvi and everyone else present on the show. And thank you, Vikas, for making sure that I really join in, and otherwise I wouldn't have benefited from this wonderful talk. Thank you, Justice Shah.
Thank you so much. Thank you.
Ma'am, before we take one question on the Facebook is by Rakesh Singh. He says, sir, are the decisions given by permanent lok adalats appealable? What kind of disputes can be referred to permanent lok adalat, and pecuniary jurisdiction, etc.?
As I mentioned, cases against public utilities, these are the cases which can go to permanent lok adalats, provided the amount involved is up to rupees 10 lakhs. And those lok adalats will first try for settlement. In case settlement is not possible, then they can give verdict on merits by following the principles of natural justice and equity, etc. And once the case the verdict is given by the permanent lok adalat, there is no appeal, but writ petition can be filed under Article 227 of the Constitution, because it's a tribunal in that sense.
So this is by Krishnan Sivamakran. Banks declared certain pockets of cities or towns as negative pockets. Those who stay on those areas will not be provided of the credit card facilities. Whether bank, as a matter of policy decision, can deny credit card facilities to a lawyer?
Is it similar to the lawyer not getting a flat on rent? But bank, of course, bank may be cautious in certain categories of cases. But of course, banks cannot deny a credit card that is a lawyer.
Vikas, can I come in?
Yes, sir. You are the. It's your platform. I am just a sutradhar.
Thank you, Vikas. Thank you, Justice Mohit Shah, for that wonderful presentation on this alternate dispute resolution. Because I, as a law secretary, was also ex officio member of the Law Commission when this amendments were brought in 2015, and was also responsible for its introduction of the bill in the Parliament. And at the same time, the Commercial Courts Act was also passed almost at the same time, because they were taken up simultaneously before the Parliament and were passed simultaneously also. Now, you were talking about Section 89. I think Section 89 mandates all the courts that before actually starting adjudication, they must try and persuade the parties to adopt this alternate dispute resolution mechanism. So there is a mandate already available to the courts, and in case the settlement is arrived at, then that need to be implemented by the court as a decree of the court. Now, what I'm saying is that if we talk about the mediation, normally in a mediation, the job of the mediator is to bring the parties on a table and the parties themselves arrive at a settlement. In our case, in India, I think the success of mediation has been because here it is a court-monitored mediation. And therefore, because ultimately the court passes a decree, therefore the mediation success rate, whatever you have quoted, is correct. And I appreciate that. That is the practice which we need to follow. Because in our country, I think most of the people believe in litigation, because I have come across cases where even brothers fighting, and they will always say, "Acha, main tumhe Supreme Court tak dekh lunga." To deal with such a people, probably this kind of provision of Section 89 was needed. But if we have really want the mediation to succeed, I think probably, I think one of the questions, answering one of the questions earlier also, you have said that probably we have to enlighten the people, we have to educate the people so that there is a structured approach to mediation. Now, of course,
Correct.
in ad hoc basis, we have already started. Section 89 we incorporated. In the Commercial Court Act, the provision has been made. The recently passed Consumer Protection Act also makes a provision
Correct.
for mediation. And what we are doing, sector specific we are doing. But I think a time has come when we should pass a general law dealing with mediation. Maybe I think if the law is passed, probably people will more aware about it. The other point which I want to make is with regard to the arbitration, and this is ad hoc arbitration versus institutional arbitration. Unfortunately, in our country, and I'm sorry to say this, most of the time, you said it, that even the non-advocates and non-judges can also be appointed as arbitrators. But what is happening in our countries most of the time, and I'm talking about because I'm myself doing arbitration, most of the PSUs and bigger companies, they always look for a judge to be the arbitrator. Obviously,
because we consider it as an alternative dispute resolution.
Yes,
so it has become an extension of the court process.
Exactly. And most of the time it is the advocates only who are appearing and arguing before the arbitrator. And I think if little informal procedure can be adopted in arbitration, and as we know, strict rules of CPC and evidence are not applicable here. It is principles of natural justice on the basis of equity the decisions are to be taken. Therefore, I can share my experience in most of the PSUs in their contract, commercial contracts, when they enter into contract, they have already made a provision that before starting arbitration, they will enter into conciliation proceeding. And in the conciliation proceeding, they have said that it will not be the judges. It will be a financial expert, it will be a technical expert, and a man who has got a legal knowledge and who has worked either with the government or has practiced as a law. Lawyer can be appointed in the conciliation proceeding so that all the three are available. But my concern right now is in India, in spite of the fact that we have passed a law in 2019, in spite of that, the institutional arbitration is not taking up and still ad hoc arbitration is going on. In spite of the fact that we have brought some sense in the ad hoc arbitration also,
I can just
providing a fee structure.
I can make one observation on what you are pointing out.
Please.
You see, in arbitration, the confidence which the parties have in the third neutral party is so important that there is no appeal against that award on merits. It is on only very limited grounds that an arbitral award can be set aside. Therefore, the parties, those who go for arbitration, are keen to see that they have an arbitrator of their choice. Therefore, they do not like to go for institutional arbitration. I'm just telling you about the overall Indian psyche.
But Lordship, why it is happening only in India? What about Singapore? What about Hong Kong? What about UK?
Correct. Therefore, that is what I'm saying, that because all this time, the people were thinking that in courtroom battles, they don't have a choice who will be their judge. In arbitration, there will be no appeal on merits. Therefore, they should have full confidence in the judge. They should know the judge or the arbitrator who is going to hear and decide their case. So that is why maybe the people are not very keen to go for institutional arbitration. That is what my perception is.
No,
but I see a very, very interesting question about section 42A.
Yes.
If that question can be shown.
That's I can read the question. That is by Sonali Sahu. I would like to know if section 42A infringes the disclosure requirements under the SEBI law.
Yes. Now, section 42A is recently introduced, correct, in 2019 amendment. You see, what happens is that in mediation meetings, there are even separate sessions, private sessions, where one party discusses with the mediator, or there may be joint sessions where both the parties discuss. Now, whatever is discussed at mediation meetings is not supposed to be revealed outside. So if the case, for some reason, if the mediation is not successful and you go back to the court, then you are not supposed to say that, oh, in mediation, he said this or he said that, and therefore he is bound by it. Then if that kind of attitude is allowed, then people will not be frank in mediation. So in mediation, people are supposed to be frank. The confidentiality is to such an extent that when the mediation fails, the mediator in his report simply says the mediation has failed. The mediator is not supposed to give reasons why mediation failed. Otherwise, he will say that the petitioner was unfair or not honest, etc. Therefore, mediation has failed. No, he is not supposed to give a single reason for failure of mediation. He is supposed to simply submit the failure report. The court, the learned judge who has assigned the case for mediation cannot ask the mediator or a party why the mediation has failed. Neither the judge who referred the case nor the judge to whom the case is now going back after mediation. None of them can ask the mediator or any party why mediation failed. What did he say during mediation? Because mediation is supposed to be such confidential process that it is only that confidentiality which gives it strength. Now, the question about SEBI disclosures. So what is the context in which that question is framed? If the
So we will unmute Sonali. Meanwhile, we have unmuted
yes,
ma'am
if
Deshmukh.
the queries can explain.
We have unmuted Deshmukh, ma'am. You said that you wanted certain insights. One thing I can say that we have unmuted her for the first time, but she has been regular following a lot of webinars that I could see on the because invariably large number of people do not disclose their identity. She has been attending the webinars. That gives us a flip to do more. Yes, sir.
Good evening, Your Lordships. It was absolutely a pleasure to hear you with all your wisdom, your experience that you have been as a lawyer and as a judge. Yes, practicing in the family courts, this question of mediation, settlement is absolutely of prime importance because it deals with the lives of the husband, the wife, and the children, as you have given us.
Correct.
So in my view, Your Lordships, there are provisions, there are procedures which are there. But the first level of comfort that a client has is with his lawyer. So he or she trusts the lawyer and wants to do that. So I feel if there is a training course which is mandatorily given to those lawyers who specialize in family law, that this would be their first duty towards their client and towards the law, that they have to ask them to settle their matters amicably, respectfully, and gracefully, and only opt for litigation as a last resort. If the training is given, then the lawyers can do that. Sometimes what we see as a little bit senior lawyer, but see, they want to impress the client. They want to sort of, prevail upon him that I can fight for you, I can get you this. But if this is made as a part of a training, like we have family court judges who have the training, Justice Roshan Dalvi ma'am has been one of the sort of, hallmark of this, and she has been advocating that. She was also our principal judge in the family court. But, and she would probably agree with me, ma'am, that there are certain lawyers who need to be trained about it. And if this becomes, and the first legal notice that goes, as you rightly said, Your Lordship, should necessarily contain no allegations of any nature whatsoever, except that there are disputes and without prejudice to the rights and contentions, so that if it doesn't get done, then the courts and the proceedings are there. So I think that's something which I would suggest that if it is made, ma'am, Justice, ma'am, do you think this is a correct thing to do, Justice Dalvi?
Yes. In fact, I always advocate mediation for these kind of matters. And if you remember, you had come for a seminar which we had with Justice Khanvilkar.
Yes.
You were invited by us among some of the lawyers. And we had told you that in the notice that you first send, there is a germ of settlement. And if the germ settles in, the settlement would come. And if that settlement comes, your image increases actually.
Absolutely.
Not that, I don't know why lawyers have got that complex that if it is settled, it just goes by the board. It doesn't go by the board. You are a semi-judge. And if you have that kind of an image, there'll be n number of people who will come to you because the family courts are packed to capacity with work.
Yes.
And then when there are some legal questions involved, like for example, in your injunction applications, etc., then you have to leave it to the court and you have to fight it out. Because then you get an answer on merit of the law. So you get a law settled. So, there must be a proper line which must be drawn. It must not be that courts are no use and therefore you must all go. And it must not also be that only courts and nothing else. That is what I always told. And in fact, in one of my webinars, which I just had with the Kerala lawyers, for 2 hours, I said this thing.
Yes, absolutely.
I don't know how many notices you, Ms. Mrinalini Deshmukh, has sent, making this without prejudice offer for the first time. I don't know.
100 out of 100.
Okay.
I can say that with my hand on my heart, I never ever start any legal notice without just giving an opportunity to invite the other side to come with his or her lawyer.
How many matters has it worked?
So I think this reorientation of the lawyers is, I think, necessary. For
yes, this is what I was thinking.
Introducing this positivity into the system.
So your ladyship, it again depends on each individual case which is there. Yes. But I would say to a large extent, and I would be sort of, honest enough to say at least 40 to 50% of the cases, we've been able to bring about something without getting into a litigation, without getting into this, muck throwing at each other and allegations and counter allegations. But as a matter of rule, I even tell all my juniors in my chamber that it has to be a very, very simply worded, like an invite to the other side, that can you come across over a cup of tea to discuss what these issues are. And that's the way. And I think if that's the training given in our courts, that will also make it a little impressive for the junior lawyers who are, because now you see Justice Dalvi, family court is flooded with lawyers. When I started back, there were hardly 25, 30 lawyers which were there. But today all lawyers want to do family law for reasons best known to them. So I think this becomes, and thank you so much for giving me an opportunity, Mr. Vikas, to express my views before these two learned lordships before whom I've appeared.
In fact, ma'am, I said, in fact, you would recollect once you had posted one question, I had asked you, I can unmute you. Because once you are a moderator, you can actually analyze a person that the way one is, and I always find that you're jotting the notes. So you can actually visualize that what I had said at the first instance when we started this webinar particularly, that this is one platform where it's no captivated audience. Like we invariably, since I am also a trained mediator, we used to say that sometimes there are captivated audience just for the sake of that there is a message that you have to attend the webinar, their seminar, they are attending it. But a webinar is a platform where persons come by the topic, by the speaker, and what knowledge sharing could be there. And like Justice Shah said, negotiations within the shadow of law is true. But one aspect, sir, which I've experienced as a lawyer, is invariably we always find that at least in the matrimonial cases, if we promote pre-litigation mediation, that actually works, especially once a person, a husband or a wife, once he gets a notice from the police station to the effect, let's assume even for the conciliation part. Actually, I have seen large number of people, they just get jittery, they are nervous, the entire system breakdowns. Once it is said, the message is that it's a pre-litigation process of settlement. Then I think it triggers off in the right sense, rather than the notice going from the police. The image itself changes.
In Gujarat, especially in Ahmedabad, we have a permanent legal aid clinic. So permanent legal aid clinic means, and it is open 24 hours a day. So whoever has any such problem can go to the legal aid clinic, and the legal aid clinic will call the other side and make them discuss with the help of a counselor who is a trained lawyer who is trained in counseling. So, instead of going to a police station, parties can go to this permanent legal aid clinic and then have their disputes resolved.
So, but I think comparatively, there is less sensitization on that aspect. Probably Justice Roshan Dalvi and Justice Vineet Kothari and Mr. Malhotra is there, and then Deshmukh ma'am. We can. That's my personal take. Maybe I may be wrong on that aspect. But at least I personally feel that if we go for a pre-litigation mediation, especially when you are called at the police station, and that sensitization is there, and in fact the police or the public at large is sensitized, then things will be a different way. Because once a party goes behind the bars, then it becomes very difficult, and the parties have a very tough standard, as we say in mediation, that it's very difficult for the parties to actually budge.
In fact, that was also the judgment of, I think, Justice Goel and Justice Lalit, no?
Justice A.K. Goel, which contemplated large number of things.
Which was then,
yes,
reversed.
Yes.
Yes. Yes, any questions?
Justice Kothari also, I said that.
Justice Roshan Dalvi wanted to say something. Please.
No, I just wanted to say that when I was the principal judge of the family court, I had started pre-litigation mediation, and I used to send the parties who would come for some kind of questioning, etc., to my legal aid clinic in the family court. And I was told that some of the matters did work out, because the women, when they got a notice, they felt, oh my God, what is it? You know, the small time women. And we would call the men, my counselors would call the men, and then they would work it out. When the when the women had to send the notice, then they would say that, you know, we don't want to go to court. We want him to do this thing, that thing, one of these things. And they actually wanted mediation. And therefore, Chief Justice Mohit Shah and myself, in Jaya Sagre's case, we have said that this mediation under the DV Act is also pre-litigation and must be allowed even before you go in. So we have struck down a government circular at that time which said that only after you go to the DV court can you then go for mediation. And we said no, because we called for several counselors like TIS and Lawyers Collective and Majlis and all of them. And they all said that mediation is working at that stage. And he said, by all means, go on. Only exception was grave physical violence. Then you cannot say, now you go to mediate and settle with this violator.
That Khap Panchayat, you know, that is what I said. We don't send women to Khap Panchayats, you know, that's what I said.
Yes.
Yes.
Yeah, can I give one observation, sir?
Yes.
I agree totally with Justice Galvi and Mrinalini Madam. But I think unless pre-litigation mediation is made a sort of compulsory, unless people are shown the way that through this passage only you can reach the court. As Mr. Malhotra also rightly pointed out, Section 89 long ago has this mandate also. But unfortunately, we have lost the way. So the new mediation law, which we are now in the process of getting, I mean, that's under formation.
Brother Kothari, on this issue, why Section 89 is not being implemented properly, let me share this. This is my perception, of course. Somehow lawyers as well as judges look down upon the other methods of dispute resolution as some kind of a, you know, second hand, the alternative methods. That is why it is Section 89 is not being properly implemented, because if the judges look down upon alternative or appropriate resolution methods as, you know, something below the intellectual level, below the intellectual level, correct. So if once that mentality changes, and therefore in Maharashtra we trained about 1200 to 1300 judges into mediation, so that at least they would be receptive to sending cases for mediation. They will be referring cases for mediation. Many of them acted as mediators.
Entire mediation system in our country is in the evolution process. We are yet to have very good number of mature, good trainers and trained mediators also. So let us hope that until this institution as a mediation as an institution gets its maturity, because lawyers like Madam Mrinalini and are very few in numbers. Lawyers would like to take the parties to the courts because that is where their economic gains are met properly. So to advise them at the beginning that you go for mediation cannot be expected from all the lawyers as of now. Practically, it is slightly not possible. Therefore, if it is by law, it is made compulsory also, and then training part takes care of the suspect also. Then both sides we can meet the bull by the horns, as they say. And then only I think mediation as a good ADR can come. That's what my understanding is. And in Tamil Nadu also, we are training not only for mediation of all aspects, but online mediation also. We already started the programs, and we are just awaiting the formal guidelines from NALSA. Once they approve the guidelines for online mediations, I think we have already trained our people for the various softwares which are available on WebEx and Polycom and all these platforms.
And when there is online mediation, there will be more people. There will be more people who will be coming forward for mediation also.
Yes. Online mediation will be in vogue very soon. We are committee level also, we are finalizing the guidelines, and NALSA also we are approaching them to give a approval kind of thing, so that real online mediation these days COVID times.
Yes, because now
I will just say that the point, as Justice Kothari said, one thing is, though we are talking much during these days of sanitization, etc., I would say rather the sanitization of the thought process amongst us is required, and coupled with the sensitization. And the 4 steps which you shared in that PPT, not on the PPT, but you otherwise said, any evolution of the step, otherwise it's also commonly known that what we say is that first is resistance, then is silence, and then is the acceptance. They are the 3 stages of any thought process. So point what you have given the insights from away from courtroom battles way forward has actually triggered off a thought process. And before we had connected you on a platform that you requested we'd asked Justice Roshan Dalvi, and we would be coming forth on one of the platforms on gender sensitization and the subjects for which ma'am is known. Rather, yesterday I was talking to a professor of a National Judicial Academy. He said that we should have the insights. I said, no, we have already taken. And I would, on that particular day, I will connect with ma'am, or I will ask Deshmukh ma'am, since she also has an immense knowledge on that topic when we have gender sensitization and remedies of third way process. We will ask her to connect on that particular day. At that day, we will also ask Justice Shalini to join us. And Justice Vineet Kothari, as always, he's been a backbone for giving insights. So, it has been in fact, a fascinating session. As you could see, I was just noting it down. It's one of the rare platforms where we create an invite of one particular judge, and people find that this platform is good. We are having different judges of their own coming. It shows that actually people, and including the judges, former and sitting judges, are quite sensitized about this issue. And we should actually look for the methods of resolving outside the courtroom, etc. Like we had Justice Roshan Dalvi, Justice Vineet Kothari, Justice Moshmi Bhattacharya. Then we had senior advocate Esteemed Pandya being a former president of the Gujarat Bar. It also shows we had also one Joy Shah, he was also senior advocate, connecting with us. And then Deshmukh ma'am, coupled with the fact Justice S.D. Anand joining firstly on this platform and then on the Facebook. So it only shows that at least what Justice Roshan Dalvi said, that germination of that thought process should be done. I think at least that germination part is over. At least we have of the level of the shrub, or we can say that at least they have grown into the plants. The only way is that how we convert into a tree which can give shade and fruits at the same time. And because of your insights and inputs, those who have been connected with you, Justice Roshan Dalvi has, as she said, that she has shared the division benches with you. Justice Vineet Kothari has already known you. Justice Moshmi has said that while you were in Calcutta. So it was a fascinating session. Now there are so many people. Before we actually, invariably we ask someone to say the formal vote of thanks. We had the ideas from Mr. Vineet Kothari, Roshan Dalvi, Justice Moshmi Bhattacharya. Before we actually sign off for today, tomorrow we have a session on changing dimensions of public employment by Dr. Pushpendra Singh Bhati, a sitting judge of the Rajasthan High Court. So everyone, we as usual say, request that once a speaker of immense knowledge comes and shares his knowledge, at least during this lockdown, do join with us, stay connected, stay healthy. I will ask Mr. Pandya, who was I can say, a key resource person to connect us with all this resourceful people. So a formal vote of thanks coming from Mr. I have been just told that Mr. Pandya has left. So Justice Roshan Dalvi would be coming. I will request Justice Vineet Kothari on behalf of all of us, since we believe that now he's also part of the family of the thought process, that we should unlock the minds during this. So over to you.
Thank you.
Sir, you have probably muted yourself. I will unmute. Meanwhile, Justice Shah, we have been receiving requests that if the PPTs could be shared.
Well, actually, there are some quotations so that I can put the quotations in the PPT and then circulate.
Right, sir. I will ask Rajat to share it on the platform.
Yes.
He will share it with me on the WhatsApp. In fact, now we have around 11 groups of Beyond Law CLC of the WhatsApp. So around 300 people have connected with us on the WhatsApp itself.
So from 11 slides, we can make it 20 slides, you know. So.
Right, sir. Right, sir. Over to you, Justice Kothari.
A formal thank is not what Justice Shah needs, but we are very, very grateful actually to Justice Shah for sparing his valuable time and with this kind of rich experience which he has throughout his life and the kind, humane personality which he is. I think sharing the thoughts on a effective alternative dispute resolution mechanism like mediation, which is the subject which I also love, and as sitting judge recently, last year only, I also took 40 hours training with a batch of 26 sitting judges of Madras High Court. And my wife is also a trained mediator. So I think, sir, post-retirement, I'm going to join the bandwagon of mediators in the legal solutions. The kind of evolution which this process is taking place in India, we can soon come up to the expectation of US, and grateful Shah for sharing thoughts on this entire process and taking the lead, and we have the effect which experience, shared his thoughts, and seeing Pani and also there for some time. And we are very happy to be with you, sir, in this webinar and also have a. Thank you very much, sir. With these words.
Thank you, sir. Probably
anything else you wanted to say, Vikas?
Sir, probably that bandwidth at your end is slightly low, but I am just reminded a famous a politician as well as a good orator, everybody knows it, and a famous cricketer saying he's not only he connects it in a different way. Though I can only say that Justice Mohit Shah was not only Shah but Shahon ka Shah, he's only Shahenshah.
No, please.
Right, sir. So everyone stay safe, stay healthy, and tomorrow at 4 p.m. in yet another endeavor to enrich ourselves. Thank you, everyone who have joined us, not only on the platform as well as on the Facebook. Stay safe and stay healthy. Right, sir.
Thank you so much. Thank you.
Namaste, sir.